Good morning and welcome to the Fed Nexus Law Government Contracts Industry Report for the week of September 15th. I'm Jennifer Aubel. Our special guest today is Candace Clokey. But before we get to her interview, I wanted to talk about a couple of events that have happened in the government contracts industry in the past week. First of all, we have Ann Rung being approved by the Senate to become the new administrator for the Office of Federal Procurement Policy, OFPP. Ann comes to us from the Office of Management and Budget, and she has a long history in government service working for the GSA and also for the Department of Commerce. I expect her to start hitting the speaking trail before too long once she decides what her talking points will be. And it'll be interesting for us to follow to see how she handles the issue of strategic sourcing, which was a pet project for her predecessor, Joe Jordan. Another big event that happened in government contracts law is a decision that was issued from the D.C. Circuit Court of Appeals in regard to Trade Agreements Act and the False Claims Act. For once, this was actually very favorable to contractors. In the decision, the court held that the contractor was able to reasonably rely on the Trade Agreements Act certifications that were given by the manufacturer. Therefore, it was not held to have liability under the Trade Agreements Act because it made reasonable efforts to ensure that it was getting the correct information from the manufacturer. So this is something that can very much impact GSA scheduled contractors, especially those who are resellers of products. And now we're moving on to our next segment. We're going to talk about our blog for the week. And with us in studio is Candace Clokey. Candace is a consultant with our GSA schedules practice here at Fed Nexus. Welcome, Candace.
Thanks, Jennifer.
So in this week's blog, Are Your Employees Really Who You Say They Are? GSA wants to know. Candace discusses a really important change that's coming up to contractor assistance visits that's going to affect professional services offerers. So Candace, what exactly is GSA proposing to do in the contractor assistance visit now?
So Jennifer, last week GSA announced via its STEPS newsletter that scheduled contractors providing professional services may now be required during contractor assistant visits to prove that the personnel they are using on GSA task orders meet the qualifications outlined in their GSA contract. This is the labor qualification, so minimum education, minimum experience. They want to make sure that those personnel you're using, billing under a program manager that requires 10 years of experience and a master's degree, that they really have that experience.
That is a pretty significant change in some of the documentation that they're going to be looking at now in contractor assistance visits. And in your blog, you talk about how they can request resumes, timesheets, and other personnel documentation needed to substantiate these qualifications. So this is a pretty big deal for professional services contractors. Why, Candace, do you think now that they're starting to do this?
Well, GSA's Office of Inspector General, the OIG, noted in its annual reports on major schedule issues that over a quarter of the schedule holders they audited that provided professional services on GSA task orders did not meet the minimum qualifications as required by their contract. Now, when this happens, OIG views this as an overcharge and requires the contractor to repay the ordering agency the difference in rate between the billed labor category and the category the individual actually qualified for. The OIG concluded that GSA customers were overcharged approximately $3 million in fiscal year 11 alone due to the use of unqualified labor.
And $3 million is quite a significant finding when you consider that the audit sample that they were looking at was a pretty small number of contractors. So if you want to take a look at those in more detail, Candace has included hyperlinks to both of those reports from her blog. So, Candace, one of the things I know that a lot of our listeners are probably wondering is, what do they need to do to get prepared for this?
Well, Jennifer, you mentioned earlier how the IOA can now request resumes, timesheets, and other personnel documentation at the time of the CAV. So I think the most important thing for scheduled contractors to do is implement some type of process to update personnel files on an annual basis, and specifically their resume. This will make sure that all their certifications or education and experience are up to date. And so when the IOA comes to look at this documentation, that way they have no reason to believe that you've used an employee that's underqualified.
That's a good recommendation, Candace, and I recommend that our listeners check out Candace's blog for more information about best practices, including the treatment of subcontractors, which can be a very tricky issue for professional service providers. So that does it for this week of Government Contracts Industry Reports. I'm Jennifer Aubel here with Candace Clokey. Thank you for joining us, and we'll see you next week.